he did not intend to use his car as a weapon. 3. In deciding to take a knife with him, Hassan Janga was prepared to use the knife if need be. He went over to College Close expecting trouble, and that's why he took the knife. However, he had not formulated a plan to use it against any particular person or in particular circumstances. 4. His decision to drive his car deliberately at Riyasat Khan was taken as he came round the corner of Scott Road into College Close. In driving at Riyasat Khan, he used his car as a weapon, and he intended to cause Riyasat Khan serious harm. He did not intend to kill him. 5. He did not appreciate the presence of the 4 people on the ground behind Riyasat Khan and did not intend to cause harm to them specifically. And 6. As regards the stabbing of Hassan Khan, at the time Hassan Khan was armed with a baseball bat. Hassan Janga produced and used his knife in the course of the fight with Hassan Khan. The verdict of the jury in rejecting self-defence is consistent with Hassan Janga having perceived a threat from Hassan Khan, but having used an unreasonable degree of force in response. Hassan Janga, I address you first. The sentence for murder is fixed by law. It is a life sentence. The court must impose this life sentence and must also specify the minimum term which must elapse before you can be considered for release on licence. So that there is no misunderstanding, the minimum term is not the point in time when you will be released. It is the minimum term you must serve before you are considered for release. Whether you are released then, or indeed ever, is a matter for the parole board, not for me. If and when you are released, you will remain on licence for the rest of your life and liable to recall if you commit any further offence or breach the terms of that licence. In setting the minimum term, I am required to take account of the seriousness of the combination of this offence of murder and any one or more offences associated with it. Schedule 21 of the Sentencing Act 2020 sets out the approach which I must adopt in deciding what minimum term you must serve. I must first identify the appropriate starting point for that term before going on to consider and balance the aggravating and mitigating factors. Paragraph 3 of Schedule 21, which provides for a 30-year starting point, does not apply in this case. Taking account of the examples set out in paragraph 3, the facts of this case do not fall within the type of case covered by paragraph 3. Paragraph 4 of Schedule 21 provides, and I quote, if the offender took a knife or other weapon to the scene intending to A, commit any offence, or B, have it available to use as a weapon, and use that knife or other weapon when committing the murder, close quote, then where the offender is aged 18 or over, the offence is normally to be regarded as sufficiently serious for the appropriate starting point in determining the minimum term to be 25 years. In this regard, there is relevant case authority as to the circumstances in which a car is to be regarded as a weapon and as a weapon which has been, and I quote, taken to the scene. I refer in particular to the recent case of Deep Rose. In my judgment, whether the car is to be regarded as a weapon which is taken to the scene is to be judged by reference to the offender's intention as to the use of the car at the point at which the offender set off to the scene. In the present case, I am satisfied so that I am sure that in committing the murder of Chris Marriott, you used your car as a weapon. However, as I have found, and whilst I am satisfied that when you set out you were prepared to cause harm at the scene, I am not satisfied that you intended to use the car as a weapon. At that point, the car was your means of transport from Whiteways Road to College Close. Nor do I consider that the fact that you took the knife to the scene brings your case within paragraph 4, as that knife was not used in committing the murder of Chris Marriott, and I refer to the case of Crown and Malt in that regard. In these circumstances, I consider that the offence was not sufficiently serious to warrant a 25-year starting point. Accordingly, I find that the starting point for the minimum term is 15 years. However, this starting point falls to be adjusted, first by the aggravating features of the offence itself, and secondly to take account of the 5 other offences committed against others that day, and finally by reference to the mitigating features of the offence itself and your personal mitigation. As regards aggravating features of this offence, first, the use of the car as a weapon on the spur of the moment to commit the murder is a serious aggravating factor which warrants a substantial increase to this starting point. Secondly, the fact that Chris Marriott, a passer-by, was engaged in the public-spirited and selfless act of assisting a young woman who was lying apparently unconscious in the street is a further aggravating factor of the offence. Moreover, the 2 further offences of wounding with intent and the 3 offences of causing grievous bodily harm with intent in relation to the 4 others that you hit with your car, that is Riasat Khan, Alison Norris and your mother and your sister, and the stabbing of Hassan Khan, warrant a further substantial increase in the minimum term. As I explain in a moment, there will be distinct sentences for those offences to be served concurrently to the life sentence for this offence of murder. As these are to be served concurrently to the life sentence, it is necessary to reflect the gravity of these offences in the overall minimum term which you will serve for this offence of murder. As regards mitigating factors, I have found that in causing the death of Chris Marriott, you intended to cause serious bodily harm rather than to kill. There was no premeditation. I also take into account that your initial motivation for driving to the scene was to assist your sister, Nafisa. As regards your personal mitigation, you have no previous convictions. In addition, some mitigation is provided by your relatively young age at the time of the events. You were 23. I have also taken account both of your personal circumstances as referred to in 2 medical reports and mentioned 2 in the pre-sentence report, and of the letters that I have received from you personally and from others. Balancing these aggravating and mitigating factors, there will be a very substantial increase from the starting point of 15 years. I turn to consider your sentences for the 3 offences of causing grievous bodily harm with intent and 2 offences of wounding with intent. I have considered and apply the relevant sentencing council's guideline for these offences. In relation to count 4, the offence of wounding Hassan Khan with intent, your culpability falls within category A, arising from the use of the knife, and harm falls within category 2, the injuries caused were grave. This gives a starting point of 7 years custody with a range of 6 to 10 years custody. There are no additional aggravating factors. I take account of my finding that you acted in the belief that you were under threat and in excessive self-defence. The personal mitigation I have already referred to applies here too. There will be a concurrent determinate sentence of 7 years imprisonment for this offence. In relation to count 7, the offence of causing Alison Norris grievous bodily harm with intent, culpability falls within category A, arising from the use of the car as a weapon, and harm falls within category 2, the injuries you caused to Alison Norris were grave and she has continuing symptoms. This also gives a starting point of 7 years custody with a range of 6 to 10 years custody. The fact that Alison Norris, a passerby, went to the assistance of a young woman lying apparently unconscious in the street is an aggravating factor. By way of mitigation, again, I take account of your initial motivation for driving to the scene and the fact that you did not intend any harm to Alison Norris herself. Your personal mitigation applies to this offence too. There will be a concurrent, determinate sentence of 7 years imprisonment for this offence. In relation to counts 8 and 9, the offences of causing Ambreen Janga and Nafisa Janga grievous bodily harm with intent. In each case, your culpability falls within Category A, again arising from the use of the car as a weapon. In both these cases, the harm falls within Category 1. The injuries you caused to Ambreen Janga and to Nafisa Janga were particularly grave and life-threatening. This gives a starting point of 12 years custody with a range of 10 to 16 years custody. By way of mitigation, I take account of your initial motivation for driving to the scene and the fact that you did not intend any harm to your mother or to your sister. There will be a concurrent, determinate sentence of 11 years imprisonment for each of these two offences. Finally, in relation to count 10, the offence of wounding Riasat Khan with intent, your culpability falls within Category A, again arising from the use of the car as a weapon. The harm falls within Category 3. The injuries you caused to Riasat Khan were necessarily serious, but were neither life-threatening nor grave. This gives a starting point of 5 years custody with a range of 4 to 7 years custody. By way of mitigation, I take account again of your initial motivation for driving to the scene and your personal mitigation applies to this offence too. There will be a concurrent, determinate sentence of 4 years imprisonment for this offence. These concurrent sentences for each of these offences, as I have said, will increase the minimum term for the offence of murder. Finally, I turn to your offences of causing death by dangerous driving and causing serious injury by dangerous driving, counts 5 and 6. There will be concurrent sentences for these two offences. Moreover, because the facts of these offences are covered by the more serious offences on counts 1 and 7 to 10 respectively, they do not lead to an increase in the overall sentence which I impose. I consider and apply the relevant sentencing guideline for each of these offences. In relation to count 5, causing the death of Chris Marriott by dangerous driving, your culpability falls within Category B as you drove at a speed which was inappropriate for the prevailing conditions. This gives a starting point of 6 years custody with a range of 4 to 9 years custody. The aggravating factors are that the victim was a pedestrian and as such a vulnerable road user, and the serious injury caused to the other 4 victims by your driving. In addition to your personal mitigation, your previous good driving record is a mitigating factor. And in relation to count 6, causing serious injury to Alison Norris, Ambreen Janga, Nafisa Janga and Riasat Khan by dangerous driving, your culpability falls within Category B for the same reason, and the harm you caused falls within Category 1. This gives a starting point of 3 years custody with a range of 2 to 4 years custody. The aggravating and mitigating factors applicable to count 5 apply here too. Further mitigation is provided by the fact that 2 of the victims were your mother and sister. You pleaded guilty to both these offences at the first reasonable opportunity and are entitled to a reduction of 33% in your sentence for each. There will be a concurrent determinate sentence of 4 years for count 5 and of 2 years on count 6. In respect of counts 4 to 10, I do not consider that a finding of dangerousness is necessary or justified in view of the fact that the life sentence on count 1 will involve consideration of future risk. The statutory charge will apply in your case. Hassan Janga, please stand. On count 4, for the offence of wounding with intent, the sentence is 7 years imprisonment. On count 5, for the offence of causing death by dangerous driving, the sentence is 4 years imprisonment. On count 6, for the offence of causing injury by dangerous driving, the sentence is 2 years imprisonment. On count 7, for the offence of causing grievous bodily harm with intent, the sentence is 7 years imprisonment. On count 8, for the offence of causing grievous bodily harm with intent, the sentence is 11 years imprisonment. On count 9, for the offence of causing grievous bodily harm with intent, the offence is 11 years imprisonment. Count 10, for the offence of wounding with intent, the sentence is 4 years imprisonment. The sentences on counts 4 to 10 will be served concurrently with the sentence on count 1. On count 1, for the murder of Christian Marriott, the sentence is life imprisonment. You will serve a minimum of 26 years. From this will be deducted the 277 days which you have already spent on remand in custody, so that the minimum term which you will serve is 25 years and 89 days. You will also be disqualified from driving for the period of 5 years. That period will not have a practical effect whilst you're in custody, and therefore that period is extended to reflect the minimum term of the sentence on count 1. Accordingly, the total disqualification period will be 30 years and 89 days. When your disqualification has expired, you can apply for a driving licence, but the licence you get will be provisional until you've passed the extended test. Your total sentence is life imprisonment with a minimum term of 25 years and 89 days. You may go. You may sit. Thank you. I turn to consider your sentence, Mohammed Janga. You were convicted of perverting the course of justice. I consider and apply the sentencing guideline for this offence. As regards culpability, your offence falls in culpability factor B, since there are factors falling in both categories A and C. The underlying offence, wounding with intent on count 4, was very serious. On the other hand, your offence was unplanned, limited in scope and in duration, and unsophisticated. The balance of factors places your offence at the lower end of category B. As regards harm, your offence falls within category 3. There was limited impact on the administration of justice and minimal delay to the course of justice. A category B3 case has a starting point of 9 months custody with a range of 6 months to 1 year's custody. Given the number of category C factors, I take a starting point of 7 months. As regards aggravating factors, the offence involved concealing of evidence, but for a very limited time. As regards mitigating factors, you have no previous convictions, and I have taken into account everything that has been said in the pre-sentence report. The appropriate sentence is 6 months imprisonment. I have also considered and apply the sentencing guideline entitled Imposition of Community and Custodial Sentences, and in particular sections 2 and 3 of that guideline. Section 3 sets out the factors to consider whether it is possible to suspend a sentence of imprisonment. I also refer to the cases of Crown against Feeve and Crown against Boston, which established that in the great majority of cases of perverting the course of justice, the most important factor will be that which provides that appropriate punishment can only be achieved by immediate custody. An offence of perverting the course of justice almost always requires an immediate custodial sentence, and very compelling reasons will be needed if immediate custody is to be avoided. In the present case, I find that there are such compelling reasons. First, I accept that when you arrived on the scene after your son had committed the offences, you, along with many others present, were faced with a situation of considerable confusion and great distress. Your daughter Nafisa was trapped under the car, your wife was seriously injured, and your daughter Humara was covered in blood. You then witnessed the lifting up of the car to reveal Chris Marriott lying underneath. It was against that background that you acted impulsively to seek to hide the knife. This does not excuse your behaviour, but it goes some way to explain it. Your behaviour was short-lived, and since the knife was found by the police within a matter of minutes of you placing it in the car, it had little or no impact on the police investigation and subsequent prosecution. Secondly, the impact of an immediate custodial sentence upon you and your family will be significant. It will lead to the loss of your taxi licence. You are the principal wage earner in the family. Moreover, both your daughter Nafisa and your wife Ambreen continue to suffer the consequences of the injuries they sustained on the 27th of December. And as a result of their ongoing disabilities, you have day-to-day caring responsibilities for them and for Nafisa's children. In those circumstances, I have concluded that the appropriate sentence in your case is a suspended sentence order of 2 years' duration. There will be a custodial term of 6 months, which will be suspended for 2 years. If in the next 2 years you commit any offence, whether or not it is of the same type for which I am sentencing you today, you will be brought back to court, and it is likely that this sentence will be brought into operation, either in full or in part. You will complete 150 hours of unpaid work within the next 12 months, working when and where you are directed by your supervising officer. Also, for the next 12 months, you will be subject to a rehabilitative activity requirement. That means that you must meet with the officer supervising this requirement as and when required, and you must attend and cooperate fully with any activities that are arranged. If you fail to comply with these requirements, you will be in breach of this order, which means that you will be brought back to court and you will be liable to serve the sentence, either in full or in part. The statutory charge applies to your case. Mohammed Janga, please stand. On count 11, for the offence of perverting the course of justice, I impose a suspended sentence order of 6 months' imprisonment, suspended for 2 years, with a rehabilitation activity requirement and 150 hours of unpaid work. You too may go. Thank you.